Here we have this unprecedented argument for broad, sweeping, permanent immunity from criminal prosecutions for former presidents. We've never heard that before. This is definitely, as many things with Donald Trump, something that's unprecedented. And the justices were extremely skeptical, I would say, most of them, of that broadest possible claim that Donald Trump is making. There did seem to be some interest in providing some protections for presidents for clearly official acts, keeping those in some ways protected from criminal prosecution. But what I heard today from the justices was really a reaffirmation of the very important principle that goes back to the very beginnings of our nation, that no one is above the law, including the president, perhaps especially the president. You know, when our Constitution was drafted, it was very important that our chief executive not be a king. And absolute immunity was something that the king obviously would have enjoyed in Great Britain, and something we did not want to replicate here in the United States. So the Supreme Court, of course, seemed to recognize that, and were troubled by the assertion from Donald Trump's lawyer that he should be entitled to this type of immunity. You know, some of the arguments were about line drawing. You know, what actions might be immune from criminal prosecution, right. And that's very few.
Well, speak to us about that, the difference between an official and a private act. How is that being redefined right now?
Yeah, so they were trying very hard not to redefine it, but rather to try to draw lines based on what we already know. So the lawyer for the United States, Michael Dreeben, did a very good job of saying, you know, there's a few core things that only the president can act, for example, recognizing foreign nations or making appointments where that's just beyond the reach of congressional legislation, including criminal laws. But pretty much everything else is fair game, except if there's an as-applied challenge, which is very legalese, but basically it means that otherwise the president can be criminally liable if the facts suggest. One thing that I thought was extremely interesting that came out today was several justices, notably Amy Coney Barrett, questioned Trump's lawyers very closely about the indictment from Jack Smith and said, okay, let's go through some of these acts. You know, what he was trying to, assuming the indictment is correct, and that was an assumption that Trump's lawyer had to do, when he was trying to find these votes, when he was trying to get this fake slate of electors, was that an official presidential act or was that a private act? And Trump's lawyer did concede that several of these indicted actions were private and not official, even under their definition. And what that means is that the trial could go forward even if Trump's argument about official acts were to be accepted. And I'm not sure it will be. It's
really important.
It's very important. Now, of course, the question then gets to timing. Yeah. But I thought it was really important that there was that concession that the trial could go forward, at least in some way.
Well, and it's worth keeping in mind that while we did see specific questioning around the case here in Washington, he's claimed immunity from prosecution in the documents case as well down in Florida, which is another federal case. So how are all of these things potentially tied together? What implication could there be, not just for the case in Washington, but the case in Florida? And then also, I'm assuming this doesn't apply to the state cases like in Georgia for the election subversion, because there's multiple criminal cases that we're dealing with here.
Yes, it's a little hard to keep track, but for sure. So he's also claiming immunity, exactly right, in the documents case in Florida. You know, I think one of the things that's really important about this case, especially in terms of the timing, is that if it isn't finished before the election, and if Donald Trump were to win re-election, because it's a federal case, presumably once he took over the Justice Department, he could make it go
Pardon,
away.
And, yeah.
Yes. That is not the case, of course, when it comes to this newest Arizona indictment or the New York case that's currently underway, because those are state criminal indictments. So that's an important distinction.
It absolutely is. As we spend time with Elizabeth Wydra, President of the Constitutional Accountability Center, Supreme Court litigator, we have a voice of experience here at the table, and I want to ask you about history, precedent here. 2020, the Supreme Court rejected Donald Trump's claim of absolute immunity. To what extent could that lead us to a decision here?
Yeah, I mean, I think, you know, the court has on many occasions pushed back on the most extreme legal claims that Donald Trump has made. He has often, whether it's the election fraud, so-called election fraud claims that he did bring before courts over and over again, and he was repeatedly rebuked on those, even by judges that he himself appointed.
Yeah.
So he's often lost on these major legal claims that he's brought before the court.
They seem to be questioning that today, though. Are you sensing that this is a different conversation than we predicted or expected?
I think what they are, concerned about is drawing the line. I think in some ways the indicted actions here, the alleged actions in this particular case, subverting the will of the people, trying to stop the peaceful transfer of power, which go to the very heart of American constitutional democracy. That seems pretty clear that it's not within, the president's duty to take care of the laws, to violate them. But I think they are concerned, as they should be, the Supreme Court, about what happens in the future. So that's what I think a lot of what we heard today was about.
And we have less than a minute left, but to go back to your point about the thinking of the founders when they were actually forming our system of government and writing the Constitution with the separation of powers in 3 different branches, if you are a strict constitutionalist, is there any other way to read the question here and to read the document that would suggest that there is credibility to Trump's argument if you are a strict constitutionalist?
Absolutely not. So there's some times where history is ambiguous. This is not one of those cases. They sold the Constitution to the people in part because this president would not be a king, and in part because he could be potentially criminally liable if he committed crimes, which is a major change from the British system.